This case arises out of a burglary of some computer equipment from a school in King County, Washington. Respondent was charged with that crime, arrested, and spent a day in jail before the charges against him were dismissed. The petitioner is the deputy prosecuting attorney for the county who prepared the case against respondent. In support of her motion for an arrest warrant, she personally executed an affidavit that summarized the basis for the burglary charge. Unfortunately, in that affidavit, she made two important misstatements. First, after stating that the respondent's fingerprints had been found on the glass partition in the area from which the computer equipment was stolen, she stated that he had never been authorized to enter the premises before, when in fact he had actually worked on the installation of the glass partition on which his fingerprints were found. And secondly, she said that he had been identified by a person in an electronics store who was asked to appraise the stolen equipment when in fact that person had identified someone else. So based on those mistakes, the respondent brought a suit for damages against her, claiming that she had violated his constitutional right to be free from unreasonable seizures. The petitioner defended the case on the ground that as a prosecutor, she was entitled to absolute immunity. The district court and the Court of Appeals rejected the defense, and we granted certiorari to resolve a conflict in the circuits on the basic question. Our cases make it clear that a prosecutor is entitled to absolute immunity when she is acting as an advocate for the state in judicial proceedings. That immunity protected the petitioner in her actions in this case in drafting the various papers that commenced the proceeding and filing those and appearing in court. But the critical question in this particular case is whether that immunity also protected her when she personally swore to the truth of the false statements of fact in the certificate she filed with the court. When, in other words, she was performing the function of a complaining witness rather than that of an advocate. For reasons stated in a unanimous opinion filed with the clerk, we agree with the Court of Appeals that insofar as she acted as such a witness, she was not entitled to absolute immunity, and therefore we affirm the judgment of the Court of Appeals. Justice Scalia has filed a concurring opinion in which Justice Thomas has joined.